Good morning, Carla Hartley here. Today I am going to be talking to you about the Doctrine of Unclean Hands. And its corollary that is often forgotten, which is two wrongs don't make a right. The Doctrine of Unclean Hands has a very old history in our legal system, and it predates our legal system. It goes back to very old British law and Anglo-Saxon law. So this is something that I think has carried forward through time because it has value. This is actually kind of embodied in one of the maxims of California jurisprudence, which is you will not benefit, the court will not permit you to benefit from your own wrongdoing. Now, that's not the whole doctrine in a nutshell. Basically, the doctrine is if you have unclean hands when you're coming to the court and you're asking for relief, the court does not have to give you what you're asking for because you are deemed to have waived it or somehow, or you should be stopped from requesting that. So we want to avoid that at all costs. Now, where this comes up in family law proceedings is that very often our clients are like, well, that person didn't do what they're supposed to do, so why should I? Well, that person's been following me and recording my communications illegally, so why shouldn't I? That falls under the corollary, two wrongs do not make a right. Just because somebody robs a bank does not mean it's okay for you to rob a bank. All right. Where we see this in family law proceedings as a good example is in the obligation to produce a preliminary declaration of disclosure early in the proceedings. Family law, the family code, imposes on both parties to a dissolution proceeding an affirmative duty of disclosure regarding all assets and debts, business opportunities, etc., in which either party may have a separate or community interest or liability. It's all assets, all debts, all opportunities, all looming lawsuits. So the code requires the petitioner to produce this PDD, preliminary declaration of disclosure, in writing to the respondent within 60 days of filing and serving the petition. The code also requires that the respondent file and serve the preliminary declaration of disclosure on the petitioner within 60 days of filing and serving his response or her response. Now, here's what we often hear. That person did not do this, that, or the other thing. That person did not disclose this, that, or the other thing. Sometimes that person hasn't even done their preliminary declaration of disclosure, so why should I? That person hasn't given me bank statements. That person hasn't done this. That person hasn't done that, so why should I? The statute does not excuse one party from their duty of disclosure simply because of the non-performance of the other party. It does not. It's not okay. And this is a great example of both parties acting in frustration of what the court and what the legislature wants and requires you to do. Disclosure is necessary to enable the court to accomplish its mandated purpose in accomplishing an equitable distribution of the community estate, period. And we're not going to do something that causes the court to have problems doing its job. So, you want to come to the court with clean hands. If the petitioner has not done their preliminary declaration of disclosure or has done a very shoddy one, we still want to produce ours and to do it well so that the court knows that we are compliant. So that when we come to the court, especially since the doctrine of unclean hands tends to be most applied in evidentiary hearings or at trial, when we come to the court, we want to be able to control what we're able to ask the court for. We want to be able to control, to an extent, what the court can do or not do within the law and the facts before the court. For that reason, if the court is looking at two parties who both behaved horribly in various ways, the court can pretty much fashion whatever remedy it wants, whatever solution it wants to get control of the two parties and get this case moving forward. Very seldom will it make both parties happy. Very seldom will it make either party happy unless they're just so angry with the other party that they're just happy the other side didn't get what they wanted. This is a war of attrition in that case, and it's not going to help you. What we want to do is have you come to the court with clean hands, having complied, so that when we ask the court for the relief that you want, the court is inclined to view you favorably. So your takeaway from this is you need three things. You need three things to get a good ruling in the court. You need good evidence. You need evidence. That's what the lawyer's for, to collect evidence and get it before the court in an admissible format. You need law that provides a basis for the relief you're requesting. You can't get around that. You've got to have a legal basis for what you're requesting. And then the last thing is you need to have a court inclined to grant what you're asking. Some of this is law and facts, but if the other side can point out all the bad stuff you did, the court's going to be a lot less inclined to be gracious to you. All right, that's all I have for today. I hope this is helpful, and I do sincerely hope that in the near future, the clients that I have coming in here have watched this and will be like, okay, I get it. Two wrongs don't make a right. Thank you. Have a good day.